start with the motion number 7, the City of Asheville motion first, and then get back to the others. I appreciate everyone's patience. Going through the motions calendar, GNC versus auto owners, my calendar says that notice has been withdrawn. Marlowe versus Maynard, notice withdrawn. Giddings versus Pelham.
Yes, Your Honor. My name is Elizabeth Newman. I represent plaintiffs. That's just a motion to approve minor settlement, and the plaintiff and minor plaintiffs are here.
All right, we'll get to that shortly.
Thank you, Your Honor.
On the second page, Distinctive Buildings versus Used at Reynolds Mountain. My calendar says that case has been rescheduled. Feingold versus King.
Mayor, Police Court, Perry Fisher for the plaintiff. We have a pro se defendant, discovery dispute, probably 45 minutes.
Yes, ma'am.
I'm Catherine King.
Right.
I'm pro se.
Thank you. Jones versus Hall. My calendar says that case has been settled. And then City of Asheville versus Asheville Police Department and other people. I'm ready to start that motion. Well, I think it has some add-on motions. I'm sorry, I need to mention those first. Herman versus Barber and Wells Fargo Bank.
Good morning, Your Honor. I'm Heather Goldstein, representing the petitioners in that, and probably the next one on the calendar also, which is Anderson versus Barber, Wells Fargo. These are two companion trust terminations, and we have a consent of all the parties.
Thank you. We'll get those in a few moments. And there's another add-on motion, Metropolitan Sewage District versus Blue Ridge Southern Railroad. I understand that matter's been...
Yes, Your Honor. We filed a voluntary dismissal this morning.
All right. Now, those are all the motions I have. Does someone have anything else?
John Hensley, we had scheduled a minor settlement to be added onto this calendar through Mr. Schimberg, was my understanding.
Well, sir, I may have overlooked that. I don't seem to have it right now, but you'll have some time during this other hearing to locate that file. I think that's everything. All right, the parties in the City of Asheville versus Asheville Police Department, if you come forward, please. Counsel, would you please identify yourselves and who you represent?
Yes, Your Honor. I'm Robin Curran. I'm the City Attorney for the City of Asheville here on behalf of the City of Asheville. This is one of our Assistant City Attorneys, John Maddox.
Yes, sir.
And my name is Todd Lambs with the District Attorney's Office. We were provided notice of this motion. We filed an objection.
Is anyone else here?
Thomas Amberg, Your Honor. I do represent Mr. Hickman in the criminal matter. I'm here to offer my insight into it as well.
All right. There's several other officers and the police chief that are notified. I don't know who's who. Is anyone else here present for this motion?
Officer Happy Mitchell, present.
Yes, ma'am. You can step on that. This type of hearing is relatively new on the statute, so I'm ready to hear arguments.
Thank you, Your Honor. Again, I'm Robin Curran here on behalf of the City of Asheville. This is the city's petition to release certain law enforcement agency recordings, also known as body-worn cameras or body cam videos. The cameras that took the videos were worn by Asheville Police Department employees during the arrest of Johnny Jermaine Rush last August. The petition is governed by a statute which is fairly new, Your Honor. It was became effective in 2016. There's actually no appellate guidance at this time, although we understand there are some cases that have gone up to the Court of Appeals but haven't finished the process. I provided you with a copy of the amended petition and the statute, and there has been one video that has been released, which is what prompted this petition, and provided that to you last Thursday, and that is the same video that has already been released. Now, under 132 1.4a, which is the applicable statute, you are correct. There's certain information that we had to provide in the petition. Basically, what we have asked for is the video footage from 11:45 p.m. on August 24, 2017 through 2 a.m. on August 25, 2017 that relates to the arrest of Johnny Jermaine Rush. The statute also requires that certain people be given notice and an opportunity to be heard, and we have provided that to Chief Hooper as the head of the custodial law enforcement agency, and under the statute, that is the entity, which is the Asheville Police Department, that owns or leases the equipment, which captured the images, if you will, and retains those images. We've also given notice to Mr. Williams, who is here today. He has been given copies of all the videos. The district attorney is an entity that is entitled to get copies of the videos in the absence of a court order. There are 11 law enforcement personnel whose voice or image appears on the videos, and we provided notice to them as well. We also served Mr. Rush with everything in an abundance of caution, even though he's not listed in the statute. Now I'm just going to do a quick overview of the facts leading to the petition. I want to talk about the statute and then the reasons why the city filed this petition and is asking for the recordings to be released. Late in the evening on August 24th of 2017, a former Asheville Police Department officer, Christopher Hickman, and a officer in training, Verino Ruggiero, encountered Mr. Rush on or near Biltmore Avenue. The officer stopped Mr. Rush, claiming that he was jaywalking, which is crossing the street outside of the crosswalk, and events escalated, as the videos will show, and there was a chase which culminated into what has now been determined to be the use of excessive force by Mr. Hickman against Mr. Rush in apprehending and arresting him. A complaint, and I want to say that I realize the video shows some very disturbing footage. I don't want to go into that for purposes of this motion, just a little bit of background. A complaint was filed by Mr. Rush later on the day on August 25th. The police chief viewed his body camera video at that time. He was taken off the street immediately. His badge and gun were taken away, and he was placed on administrative duty. An internal investigation was underway within the police department for personnel reasons, and over the next several months, and there was an official determination that Mr. Hickman had engaged in excessive force in violation of Asheville Police Department policy. At the conclusion of that investigation, a decision was made to terminate Mr. Hickman. There was a meeting set up to communicate that decision to him, which is what is required by Asheville Police Department and city personnel policy. He came to that meeting with a letter of resignation before the chief had an opportunity to terminate him, but he has been gone from the employ of the City of Asheville since January 5th of this year of 2018. Just a couple of other events that may be relevant. In September of last year, the police department provided video footage to the district attorney, and he promptly dismissed any charges against Mr. Rush. There have now been criminal charges filed against Mr. Hickman. I'm sure the district attorney can address those better than me, and will do so considering he's responded to our motion. As I am going to explain in more detail in a minute, body camera footage under this statute is not a public record. Under North Carolina law, public records are the property of the people, and they can get a copy of them at any time. We have to provide it as promptly as possible. However, body camera footage does not fall in that category and cannot be released to the public by anyone without a court order. Nonetheless, at some point before or on February 28th of this year, an unknown source, we do not know who, obtained a copy of at least one of Mr. Hickman's videos and provided it to the Asheville Citizen-Times, which posted that video on its website on February 28th. That video has remained on the website since that time. I don't know if it's been continuous, but every time I've looked, it's been there. And now there have been thousands, if not tens of thousands of people who have seen that video, and it has gained the attention of the national news. The city council, the city officials, and residents of the city are very angry and disturbed about what they saw on that video, specifically the extreme use of force by Mr. Hickman, and it has caused significant distrust and anxiety for the residents, toward the police department, and toward the city. There have been significant concerns voiced to the city that there has not been transparency and that they want to see all the videos. That's why we're here today. The City Council, I want to emphasize, does not have authority to view these videos or release them without the court's permission. They saw these videos this video at the same time that the public did. They very much want to be able to view the videos from beginning to end. This is their police department. They don't want this to happen again, and they want the public to have all of the information that it can so that they can be completely transparent. The city does not want to withhold this information. They want the citizens to have all of the information. Now, I do want to, again, emphasize that the city cannot release this video without court's permission, and if we did so, it would be a violation of the statute. The city council nor the city staff or the police department does not want to do anything that would violate the statute in any way. So now we have filed the petition, and the question is now before Your Honor to determine whether any or all of the videos should be released. You're allowed to do or asked to do an in-camera review, and if I could approach Your Honor, I have a thumb drive with all of those videos on it with an index.
Yes, ma'am.
Now, there are a total of 9 videos. Some of these are from Mr. Hickman's body camera. Others are from other employees of the Asheville Police Department. It starts before the incident that's already been released and goes past that incident or the video. And it also has videos, footage from other officers that's sort of going on at the same time. So it's got before, during, and after on those 9 videos. I do also want to say that the one that's been released, we have not been given permission to release it. So in order for us to give it to anybody other than Your Honor, I think we need a court order for that as well. Now, with respect to, I just want to touch on an overview of body-worn cameras and the statute. 132 1.4a is entitled Law Enforcement Agency Recording. Again, it went into effect in 2016. There are a few definitions in the statute that might be relevant. One is the definition of a body-worn camera, which is an operational video or digital camera allowing audio and video capture of interactions between law enforcement and the public. Now, in Asheville, a pilot program was started in the summer of 2016 where they just started to try out using body-worn cameras. That was in by the next summer, which was shortly before this incident of 2017, the summer of 2017, the majority of the uniformed officers in the field had these cameras. Now, generally, they're worn on their chest or on their shoulders, and they have a policy, an internal policy, which the statute requires that basically tells them what the procedures are to operate this equipment. Generally, the body-worn cameras are activated to record contact with citizens in the performance of official duties. Now, a recording is a visual audio or visual and audio recording captured by a body-worn camera, among other devices. And that is showing the interaction between the law enforcement personnel and the public. I do want to point out that the statute specifically accepts from the term recording any videos of internal interviews or interrogations of witnesses or suspects. Now, the statute, again, is very clear that body-worn camera recordings are not public records, but there are several circumstances where disclosure can be allowed outside of the police department, and those are disclosure and release. Now, release is what is relevant today, Your Honor, but I did want to talk about disclosure just quickly so that everyone and Your Honor has an idea about how the statute operates. Now, disclosure means to make the recording available for viewing or listening by the person requesting disclosure at a time and location chosen by the custodial law enforcement agency. This term does not include the release of a recording. So, and there is a list of people who get to be able to that the video can be disclosed to. And basically, you can come to the police department and look at it, but you can't have a copy and you can't copy it yourselves. And the people who are allowed to be disclosed, to which the video can be disclosed, are people who are actually in the video or their personal representatives. That list does not include the city council or any city personnel outside of the statute. Now, release is a step further. There's a procedure for people who want to release the video that are actually in the video, and that's a different subsection of the statute, which is F. We are here today under subsection G, which is when a person who's not in the video and is not a law enforcement agency wants to release it outside of the police department. There is a list of factors in subsection G which the court should consider in deciding whether to release the recording, and these include things like whether it would protect the integrity of a criminal investigation, whether it would put someone in danger, whether it would embarrass someone or impede the administration of justice. There's also a couple of catch-alls that you could release if it is in furtherance of a compelling public interest or there is good cause to release. The statute says that the court can conduct an in-camera review, and after that, Your Honor can decide to release all or part, or can place any conditions or restrictions on the release as you deem appropriate in your discretion. Now, our petition sets forth specifically the reasons that the city has asked that these videos be released, and I just want to go through those very quickly. First of all, we contend that release is necessary to advance a compelling public interest. And the reason is, I realize that releasing body camera video as a matter of course is not contemplated by the statute, but there are circumstances where it's appropriate. We have a situation here where a video has been released already. That was not in the city's control. And it's been provided, and numerous people have seen it, and it has caused a lot of anxiety and public distrust. And it's our position that allowing all of the videos to be released at this time will advance the compelling interest of transparency. The City Council wants to be transparent to the public with respect to this incident. They want to be able to see the videos themselves because this is their police department. They do not want this to happen again. And we believe that because one is out, releasing the rest will provide the compelling interest of letting everyone know exactly what happened on that night. Now, second, body-worn camera recordings are normally confidential under 132.1.4a. That's a statute which, of course, the city is required to comply with. But right now we have a situation where 1 of 9 videos has been released. And so we believe any interest in confidentiality no longer exists because of the release of the 1 video. And the other thing is, it's almost like the release of the 1 video has caused more speculation and anxiety than if all of them had been released. I hear pretty often descriptions from what people think the rest of the video shows, what happened before and what happened after. And so people are guessing in their mind what happened other than at this 1 snippet in time. And we believe the only way to be fair and let everyone know what happened is to be able to release them from beginning to end. Third, the city does not think that release of all 9 of the recordings would reveal information of a highly sensitive personal nature or would harm the reputation or jeopardize the danger of any person. Those are subsections G4 and 5. And the reason is because to the extent that those interests would be compromised, they've probably already done so by the release of the 1 video. We think if people can see what happened from beginning to end, from all angles, there would not be additional harm, but it would be actually beneficial for a complete picture. Now finally, the city acknowledges and realizes that there is a criminal investigation underway and that Mr. Hickman has been criminally charged. They do not want to do anything to interfere with that investigation and hope that it proceeds swiftly and effectively. On the other hand, because part of the story is out, they don't believe that, and that the use of excessive force is very clearly set forth in the video that is out there already, that any additional harm would be served. We think that good cause has been shown. The City Council has made it clear on several occasions that the conduct of the officer in this video is completely unacceptable. They want to move forward. They do not want this to happen again, and believe that release of the videos and letting them and the people see from beginning to end will be the first step in trying to resolve the issues and make sure that the police department moves forward in a productive way and that the community heals. And so that's the reason that they are asking for the release today, Your Honor. So if you have any questions of me, I'm available. Otherwise, that concludes my presentation.
Thank you. Mr. Williams.
Thank you, Judge. The compelling interest that the court should be guided by are under subpart G, the tensions, as we set out in our motion, the tensions that the court are to look at and balance are release is necessary to advance a compelling public interest, or release would create a substantial threat to a fair, impartial administration of justice. So the issues there that are key in the administration of justice are due process to the defendant, the consideration of the victims. The victim here, Johnny Rush, I've sat down on multiple occasions now, twice with him, gone over all the contents, these videos. There are a lot of statements that are made. There's personal information that's exchanged. He objects to the release of these items. We want to prosecute this case. We want to prosecute it. Number one, we don't want the release of criminal evidence in assault by strangulation, Class H felony, assault inflicting serious injury, Class A1 misdemeanor, communicating threat, Class 1 misdemeanor. We don't want to basically threaten our ability to, number one, prosecute the case at all with the advanced release of evidence in the media. We don't try cases in the media. We try them in court under the rules of evidence and criminal procedure. And number two, venue. The citizens of Buncombe County have a right under our law to have this case heard here in Buncombe County. And if these materials are pressed out at this point in time, advanced for public consumption at this early stage, rather than through the orderly administration of justice, subject to the court's approval and its admissibility in court, all of this is potentially at risk. We don't object to the ultimate release of these materials, but now is not the time to release these materials. And we'd ask the court to be guided by the Constitution of the United States, the North Carolina Constitution. I'm obligated to look after basically the victim's rights and the defendant's rights to ensure that we have an orderly administration of justice, and that's where we're guided in terms of our objection before the court here today.
Thank you. Mr. Amberg?
Yes, Your Honor. My client would strongly object to the release of this information at this point. He has a constitutional right, just like everybody else does, to have a fair jury determine his guilt or innocence. It's somewhat frustrating the city makes an argument that since this video was illegally released, that, well, let's just go ahead and release all the rest of it. I would keep that in mind at this point, Your Honor. The whole reason we're in this position where my client has all of this media attention is because somebody at the police department saw fit to release this video, not the rest of it. And I don't know what their motives were. We'll get down to that at some point. My client looks forward to having a trial. We believe that when a jury sees all of the evidence, there's all the circumstances that he'll be exonerated in this. But at this point, just releasing these extra videos out there to where everybody can see them however they want to and form their own opinions before my client ever has a chance to even get in the courtroom, I think is inappropriate and would greatly jeopardize his constitutional rights.
Thank you.
Thank you.
Officer, was it Officer Mitchell? Ma'am, you don't have to say anything, but if you have a chance to be heard if you want to say something. Is there anyone else here that was given notice of this hearing that wishes to exercise their right to be heard? I need to take a few minutes and look at this thumb drive. I'm not saying I'm going to go through every recording on it, but I'm going to go through part of every recording. So it'll be a few minutes, probably not longer than 10 minutes. We'll be at least for 10 minutes.
All rise. Time of board, 9 recess for 10 minutes. Guys, have a seat on the board.
miss doing it. It's always exciting, always something going on. Not always. No, not always exciting.
Yeah.
How do you know how long that's been there?
Oh, really? That's awesome. My daughter is I feel like this. Yeah, I think Washington County. Yeah, I think one of those. And then no, I think Washington County.
There were some amazing.
Come to order, remain seated, remain quiet. This board is now back in session.
I've gone through all these recordings, and when I say gone through them, Council, I'm sure you are familiar with when you can click on the timeline with the mouse and move things ahead a little bit more quickly to see what you want to go on to the next important thing. So obviously I didn't look at every second of it, but I think I gleaned the important parts of these recordings. Ms. Kern, I'm going to ask that you prepare a proposed order. And I'm not the most eloquent person, but I'll go over what I think is the most important things, and you might need to round it out a little bit, but it would need to be tendered to District Attorney Williams and to Attorney Mr. Anbergy for their approval as to form before it's submitted to me for my signature.
Yes, Your Honor.
And looking at the statute, I'm going to talk first about the compelling public interest. I think judges have to be careful about whether they can take judicial notice of things like this. Obviously, this has been on the media so much. I've seen portions of the video on the media, but I can't just bring my personal knowledge into this hearing. I have to rely on the representation of counsel. But I think it's clear that there is a compelling public interest. I think probably part of that is the timeline, August 24th or early August 25th. And I am cognizant of District Attorney Williams' concerns. We want everyone to get a fair trial. Of course, Mr. Ambergy's concerns. We want everyone to get a fair trial. But I think the big issue here is the timeline. August 24th. It's a long time ago. And what's been going on since then? Maybe a lot, maybe not anything. I don't know. But I think the public needs to see these. And the fact that, I know I'm talking too fast. I always talk too fast. But the fact that one of these videos has been already released, I think that makes it more a compelling public interest that the others be seen, and also lessens any damage that the release of the others may cause. When a trial is scheduled for Mr. Ambergy's client, the presiding judge can consider a motion to change venue. Can also consider just bringing jurors from another county. So the trial still could be in Buncombe County. So that's something that may, of course, is yet to be determined, and I'm sure whoever's presiding can deal with that adequately. I'm not aware of any information of a highly sensitive personal nature that would be revealed. And also, all of the recordings show a person perhaps has been alleged acting inappropriately in dealing with a defendant, well, I shouldn't, with an arrested person, I'll put it that way. And I have to be careful how I characterize these recordings, but I think they also show a lot of people doing exactly what they need to do. But the public can decide that because I'm ordering the release. I need to, without any restriction. But I need to set a time period for that in case any party wishes to invoke appellate review. which also would be on a fast track at the Court of Appeals. Ms. Kerr, you could have a proposed order prepared relatively quickly, couldn't you?
Yes, Your Honor.
And Mr. Amberg and Mr. Williams, you could review the proposed order fairly quickly, couldn't you?
Yes, sir. Yes, Your Honor.
So I'm going to be here, I think, all week. We have a trial starting at 2 o'clock, a civil trial. I need to have this order signed as soon as possible, and I'll consider any objections as to the form, of course. Perhaps,
I was going to note that I think under the civil rules that the enforcement of the order would be stayed pending the appeal time. So I think that we could deal with that for the appellate review.
I need to set a time for the release, though, don't I?
Yes, Your Honor.
Suggestions by counsel to that? This week, late this week, or early next week?
We could have through the end of the week.
Why don't we say Monday at 2, next Monday at 2 o'clock?
That'd be fine.
Ms. Kerr, would that be?
Yes, Your Honor.
All right. I think I've heard from everybody that wanted to be heard. And when I looked down and saw you writing so fast, I'm sorry, I just started saying too many things, but I'm sure you're prepared in adequate order. Is there anything else we need to deal with here today? As to this matter? I think that's everything. We're going to take a 10-minute recess to allow these folks from the media to pack up their items if they wish to do so. So we'll be in recess for 10 minutes.
All rise. Time report now, please recess for 10 minutes. I've been sitting down.
Yes, sir.